DPRO, Karnal, which were sent under UPC Miller. The comments of department were sought in this regard. Director General letter of Superintendent District Jail Karnal dated so, in which he has been mentioned that as per record available in DPRO office, no UPC letter was available, and as well as the same was not mentioned in any other correspondence. But the memorialist has now submitted a letter dated 7th March 2014, obtained through RTI. Same office supply copies of these letters.
Mr. Malik, just wait.
My lord.
When was your appeal dismissed?
2010, my lord.
9th of February 2010.
My lord.
Right?
My lord.
When did you file the memorial before the governor?
2010. 2012, my lord.
2012, 7th of May.
My lord.
2 years, 3 months. What is the limitation?
For memorial, my lord, in fact...
There is no limitation. You can take your own time.
No, my submission is, my lord. What was factually found here?
This is the first block.
My
now come to 4th of July 2014. That is the governor's order.
My lord, I'm reading that very order. Just for a minute, my lord. Just few lines more. Just few lines more. Only few lines more.
Just 1 minute.
My lord, my lord.
4th of July 2014 is the governor's order.
That's right, my lord.
Reinstatement without back wages.
My lord. My lord.
Correct?
My lord.
When did you file your writ petition?
In after 2 years.
2016, my lord.
Then why should you be paid? Why should you be paid?
Why I should be paid? Only for that reason I'm drawing your kind attention. Only for few lines, further. Page 44, page 44.
If you want back wages, then
my
we will, on your SLP, we will set aside the order of the governor and send it back for de novo consideration.
Millard, may I drive your kind attention just for Millard?
For the moon.
See, you have been given benefits,
Millard, few lines at page 44 for a minute. Millard, few lines at page 44, Millard. Just for a minute, Millard. It appears that it was all done with a malafide intention to harass and harm the memorialist. That's what the observation by the highest constitutional authority of the state, Millard.
The highest constitutional authority of the state has taken a sympathetic view, said, very well, you will get back your service, but you will not get any back wages.
But Millard, when it has been found that I was not being allowed to resume duty because of malafide intention of the department,
They are not inclined to interfere. Dismiss. 32.
My lord.
Yes, item 32.
Yes, my lord. My lord, this is enhancement petition.
Where is evidence that you were earning rupees 15,000?
Please, my lord. As a Raj Mistri, but Honorable High Court has not considered. Neither Honorable High Court, not tribunal, my lord.
High Court has said that that evidence is not reliable.
But your lordship, if I am Raj Mistri, I am working Raj Mistri.
As so 15,000, we are not disagreeing with the tribunal or the High Court. Tell us one thing.
Yes, my lord.
Did you claim any amount on account of artificial limb?
Your lordship, I have not claimed this. But my lord, what's happened? This is the fault of the council, my lord. Let us, my lord, kindly consider one leg has been
on artificial limb.
Your lordship, on the part of interest also, my lord. Interest only counted 6%, lower, my lord, at least 9% interest may be counted.
No, 9% is, there is no thumb rule of 9%.
But your lordship settled in different law, your lordship, that at least interest not on 6% is lower grade, your lordship. Kindly consider 9%.
Do not disagree with the Motor Accident Claims Tribunal and the High Court that there was insufficient evidence on record to prove that the petitioner was earning rupees 15,000 per month as a mason, within bracket, Raj Mistri, bracket closed. However, it is ascertained from Mr. Yadav, learned counsel for the petitioner, that despite he having suffered amputation of his right leg below the knee, he had not claimed any amount towards artificial limb and replacement thereof periodically. limited to the above, notice be issued as to why the petitioner shall not be awarded compensation on such account.
Actually, interest may be 7% and 8%. Kindly you also
Oh,
consider.
Interest is okay. That is the discretion. We need to leave it to the courts. Yes, item 33.
My lord, I beg to appear, my lord, in 33. My lord, I was a DCP at the relevant time. All I did was to mark the complaint to the SHO. My lord, this other side filed another complaint which was directly registered, my lord. And now this man has filed, my lord, a suit for malicious prosecution against the police officers as to, about complaints, my lord. There is nothing wrong, my lord, which has happened.
Rothki, contest the suit. It's only Order 7, Rule 11 that has been
Lord,
reversed.
just have a look at the reason, my lord, a police officer to be prosecuted for marking a complaint, my lord.
Rothki, it has been sent back for fresh consideration. Order 7, Rule 11 is to be considered de novo.
Oh, no, my lord, no. That's in the, sorry, my lord. Your lordships are, my lord, remembering the sanction case. In the sanction matter, sanction was refused. Then the DB said reconsider, and that your lordships have stayed. That's a different matter, my lord. Your lordships have stayed the grant of sanction or consideration of sanction.
Sir is remanded.
That your lordships have suspended, my lord, the
Sir, please come to paragraph 3 at page 25.
Yes, it's remanded.
Consider the plaint afresh. That means Order 7, Rule 11 has to be considered afresh.
Oh, my lord, what will remain?
Or
Your
not.
lordship, sorry, my lord, with great respect. See paragraph 2,
We
my
will
lord.
clarify that. We will
300 days
My
delay
lord,
also.
your lordship may clarify that 711 may be reheard, no problem. But not this way, my lord.
Since the High Court has
It's
made a direction with a
Last order, we see the report is already there.
concluding paragraph of the impugned judgment and order, which would result in revival of the petition under Order 7, Rule 11, Code of Civil Procedure, and has to be decided de novo by the trial court. We see no reason to interfere. Dismissed with the aforesaid
My lord, your
observation.
lordship may dispose it off, my lord. Your lordship may, my lord, it will make a difference. These are police officers facing the wrath
After
of
the
a person.
clarification that we have provided,
My lord may say disposed of is my earnest, my lord, request. These are police officers. They will face it for the rest of their lives.
dismissed. Next.
Milords, I'm requesting the same order in 33.1, Milords.
33.1, same order.
It's the delay of a year.
Item 34.
My lord, this is SLP against order passed beyond the relief claim form without cause of action and without jurisdiction.
Item number 34.
Yes, my lord.
Could you please come to page 12?
My lord, page 12.
Page 12,
My lord,
questions of law.
my lord.
A.
Yeah, yes, ma'am.
We are not reading it out. We are not reading it out. You read it yourself, right?
Whether learned single
You
judge
don't
has
have to read
acted.
it loudly. You don't have to read it loudly. You first read it, what has been stated. Once you have completed reading it, we will put you a question.
Yes, my lord, I have read.
You have read it.
I
Now,
have
the
read.
allegation that you have made, is it evident from page 6?
My lord, page 6, yes, my lord.
Is it evident from page 6?
Yes, yes, my lord, 256 Liars Chambers, Block 1, Delhi High Court.
Oh, that's the,
Page 2, the Honorable Justice, my lord, address is 256 Liars Chambers, Block 1, Delhi High Court, New Delhi. And then my lord, Lordship will kindly come on page 8. On
this,
page
the,
8,
please
my lord,
wait, this
the
chamber
victim-
number 256 belongs to whom?
Yes. Mr. Maninder Singh, my lord.
Please keep
husband of
quiet,
Honorable
please
Judge.
keep quiet.
My lord, yes. And my lord, this is,
Only for a minute. In respect of Kalkaji matters.
yes, my lord.
In a first appeal, this court has passed an order that all proceedings are stayed.
Yes. In spite of that, my lord,
So
continuously.
why the
Honorable
Delhi
Judge
High
is
Court is
passing on.
proceeding in the matter?
Proceeding, my lord, proceeding, she is continuing, not passing
Not a
such type of order. And this is, my lord, proceeding may be stayed, my lord. Even, my lord, one time, her ladyship was pleased to issue order of contempt in spite of order of status quo. Then
That was also stayed by this court.
yes, my lord, by your, yes, my lord.
But I don't understand.
Yes, my lord. Lord, there is a screenshot. Not 4 and 5. Not that's right. Yes, my lord. I haven't placed it on spot, but there is a screenshot at least.
Item number 34, Dr. Mishra.
My lord.
Do you have the order
Ma'am.
passed by Justice Bela Trivedi and Justice Satish Sharma staying
Yes,
all
ma'am.
proceedings?
Yes, my lord.
Can we take it up in the second call? Can you give us the reference of the order so that we can take out a printout?
I can, my lord, just now give that order.
Give the
that is
number and the
annexed,
date of the ROP.
that is annexed, my lord, in 6334 and order date is 18th March 2024.
It is on record.
It is on record. This
Where
is,
is that?
Where
this
is
is
that
annexed,
order?
my lord. This is annexed, my lord. Just now I'm, sorry. That is P18, my lord.
Page number.
Page
Page 285.
285.
Page
285 and
285, right?
290.
Huh?
285 to 292.
There is an order of status quo.
Yes.
Yes, my lord.
There is an order of status quo.
And after that, my lord, there are two orders staying operation of respective orders.
Where is that? Where is that?
My lord, that is
Continuously they are.
no.
Yes.
1 minute.
P18, 19, 20, 21.
Then, my lord, next order is,
This one.
Okay, order is 294.
my
This
lord,
one.
lordship will kindly see
Yes.
page 294.
Who is your employer?
Page
My lord, the
294.
state government, my lord. I am appearing for the petition, my lord.
It starts
Here
from
I am seeking
294
to
and operative portion is on page 296. And the order is, my lord,
There's so many status quo orders.
Each other.
and the order is, my lord, on a relevant portion. is on page 296.
Before. 28 May. Further proceedings of FAO number 36 of 2021 pending before the High Court of Delhi at New Delhi shall remain stayed.
Much of that. Much.
Yes, sir. Well, how do you?
Please, my lord.
Madam Trivedi, not before me,
Please, my lord. Please.
not before a bench of which DD is a member.
You are safe today. What I wrote, I'll not tell you.
Please, my lord. I'm very aware. My apologies, my lord. I realize that.
This is law, I mean.
Yes, 36.
My lords, in 36, there are two matters. I am for the landowner. Dr. Singhvi, who is waving his hand vigorously, is for the borrower.
But my lord,
He-
take the 36.1 file.
Ideally, 36.1 should start, my lord.
Yeah, you do also take the file of 36.1.
But who is the borrower? 36 or 36.1?
36.1 is borrower,
The borrower.
36 is landowner, 36 sought to intervene in the impugned proceedings. That was not granted. So 36 has an additional hurdle to climb, which is that I should be allowed my intervention. It's my land which has been put up for auction for the first time.
I am for the caveator. I am for the auction purchaser.
Just one.
All of you, just one
Yes.
clarification.
Yes.
Now, DRT and DRAT concurrently set aside the sale
In my
Yes.
favor.
on the ground of fraud,
Yes.
right?
Yes.
Now,
Yes.
the High Court of Bombay has allowed the writ petitions filed by the secured creditor and the auction purchaser
Lordship pleases.
and disposed of their petition with a direction to the DRT to consider the 17 application. Up to this, there is no confusion.
That's correct.
Yes,
Actually,
well,
that's
Lordship.
Has the High Court not said anything about the sale? What happens to the sale?
Yes.
They have
correct.
not said, Malus, and may
They've
I just,
not.
I am the petitioner. Can I just take 2 minutes, Malus?
Yes.
I've got a list of dates which is vital to show the fraud, sent yesterday to the court master and again today. It can be handed over. Just note this, Malus.
Color scheme.
I beg your pardon?
Any colored list of dates?
Yes, it's got colors in between. In between, it's got colors, Malus, because that colors are to show the colored fraud. It's to emphasize the fraud. It will become very clear. Just give me 3 or 4 minutes. Now, Malus, I am the debtor in the sense that I am a guarantor debtor. I mortgage the property on behalf of this loan. Now, Malus, 5 dates are important in sequence, and that's enough to show the fraud. Malus, there are in item 8, there are 6 failed attempts. Just note in item 8, 6 failed attempts, which is why Malus, the Lordship should be more suspicious when suddenly things are sold to Mr. Rohtgi's client. There are 6 failed attempts. Now, Malus, in item 10, I filed 2 applications, one to injunct and one a formal amendment to bring on subsequent development. This is very important, Malus. I filed an injunction application prior in item 10. The date is before my lords. This is 8th May. Now look at the fraudulent action which starts on 10th and 11th. In item 12, which is 10th May, which is the red one. Just
We are not getting
We are
it.
getting it. Or the pages hai.
list of dates. List of dates was handed over to your lordship. No, it's a list of dates. I don't know what.
We have flowchart 11th May.
No, my lord, flowchart is mine. I have circulated the flowchart.
Please give my list of dates, please. This is
I have circulated a colored flowchart to show how, my lord, the owner came, how the owner gave
Mr.
the
Rohtgi, this is not an opportunity for you to intervene. Please. I am the petitioner.
I am not intervening. I am only responding to the court's question. What is
No, we want Dr. Singhvi's list of dates. We have not got it.
Very sorry.
Just
There are the limitations of a virtual hearing.
Petitioner ka nahi aaya.
It says on top, it says on top, briefing note.
Sir, we don't have it, sir.
I have a suggestion. In my first matter, if you just come to page D for Delhi, those similar dates are there, which will show what the fraud is. Page D.
So, but it may not be
This
the
is
same chart.
Rodgers.
So, I had prepared it on that chart, but let Mr. Gopal then do it, because I have no problem. Because my chart is vital to show, can't the court master...
My lord, I have a preliminary submission. Let me place that if it meets with the lordship.
Or would your lordship do one thing, Malad, can your lordship take it on Friday? It's far too important, Malad, not to have that chart.
I don't mind, but I have a submission to make.
Land Senior Counsel, if we can just find out a via media.
So I wanted to say something on that.
17 application will be heard afresh.
Just give me 1 minute, my lord. I wanted to say something on the via media.
One clarification. The secured asset, who is in possession of it?
I am the auction purchaser. I have a confirmed sale. I am in possession. I paid everything.
No. After
Let it be decided that he should not alienate. My Mr. Rodgi is in possession.
Mr. Rodgi is in possession, you are admitting.
Yes, my lord.
And he will further alienate it, otherwise let the High Court decide.
1 minute. I have to say something else.
Can you maintain the status quo with regard to possession? Let the 17 application be decided afresh.
So, my lord is perfectly right. I have no problem. I only want to tell your lordship one thing. Justice Datta posed a question. What did the High Court do about the sale? That was the lordship's question.
Yes.
The answer is that, my lord, the DRT and DRAT set aside the sale by an interim application. In an interim application, the sale was set aside. So the High Court said, you can't set aside a sale in an interim application. That order is gone. Please argue your main case, and if you succeed, then the sale will be set aside. And that is now recorded in para 27 and para 30, my lord. So there is nothing which survives.
Friday,
and I will not maintain status quo. Turn to 1 minute, sir, if you don't mind. 1 minute, please. Turn to para 27. At this stage, counsel for the borrower submits that the respondent intends to approach DRT to amend the application. That is, my lord, for cancellation of sale. Respondent is liberty to do so. Court has not expressed opinion on the merits of parties. All questions open, para 30. All questions open before the DRT for on merits, my lord, because they will then argue not as an interim application. And only one more para, my lord, may see that your lordship will find paragraph 4 at page 4.
This is not the way, Manoj, with respect. He intervened because I had not...
I am doing something which will be in your favor. I will, my lord, not sell the property. That's what I am saying.
That's all that we are saying. We are not arguing. Why is my arguing on this?
I want your lordship to record that, my lord, I have mortgaged the property. I will not, my lord, transfer or alienate the property without the leave of the court, and their main petition may be heard, in which they will re-urge, my lord, the question of fraud. That is the legal position.
That's all we are saying, Manoj. That's all we are saying for the time being.
That's okay. Then I am saying something in your favor. What's the problem?
1 minute. I wanted this court to decide.
Yes, Dr. Singhvi, what is your response?
I wanted your lordship to decide, but I think it's a fair suggestion. We don't want your lordship to waste time. Let it be decided by the High Court with a clear recorder.
Not the High Court. It is to be decided by DRT.
DRT. I'm sorry, DRT.
DRT.
DRAT.
Not DRT.
No, DRT.
DRT.
It has to be decided.
Securitization is in DRT, my lord.
There is a Section 17 application.
Yes.
High Court has granted liberty
DRT.
to borrower to amend the Section 17 application. After the Section 17 application is amended, the DRT will hear the parties and decide the matter. Till such time, the DRT decides the matter. We will record Mr. Rodgi's undertaking that he will not alienate, encumber, or dispose of the property without obtaining the leave of the DRT.
Yes, correct. And my lord,
May I just make one submission?
One more thing. They have already, my lord, made an application for amendment pursuant to the impugned order, which was, my lord, yesterday.
Decided together, Manoj. They have decided together.
Very well. Mr. Gopal, you wanted to submit something?
One small submission. Mr. Rodgi's client has mortgaged this property to the Punjab National Bank. The Punjab National Bank sought intervention in the High Court saying that, look, we had no knowledge that there was this dispute pending and there was an order of the tribunals below. The problem is that now Mr. Rodgi can make whatever submission he wants. But since Punjab National Bank is not here before your lordships, making a similar statement, the difficulty is, would Punjab National Bank be in any way bound by this? Because as the mortgagee, they are entitled to take whatever steps is necessary. The
But
reason
that
why
is-
I am
it's-
affected.
It's a hypothetical
That-
situation. Mortgage
Sorry,
was
Mr.
created
Rodgi,
2 years
Let
ago.
me
Mr.
just
Gopal,
complete.
one thing.
Yes.
One thing,
Yes.
Mr. Rodgi has mortgaged the property.
Yes.
We will record that in the event Mr. Rodgi's client defaults in making payment of the installments,
Yes.
it shall be open to the Punjab National Bank to obtain the leave of the DRT
Absolutely.
and proceed under
Absolutely. No
complaint
problem.
against
That's
Mr.
No
Rodgi.
problem. And I will not let go of this property, my lord, just for default of the bank. I took a loan to purchase the property. I will not let it go like this.
Now,
We have-
just
we have
the
heard-
other
we have
other
heard
point
Dr.
is only
Singhvi,
this, Mala.
learned senior counsel for the petitioner in 36.1, नाम दे दीजिएगा. Mr. Gopal Shankar Narayan, learned senior counsel for the petitioner in 36, and Mr. Mukul Rodgi, learned senior counsel for the auction purchaser. Within bracket, what is your name, Mr. Rodgi?
Yes. My lord, the name is Juana R2, my lord, Juana Sanjeev,
R2.
Mrs. Juana Sanjeev Uppal.
Very well. Mrs. Joanna Sanjeev Uppal,
My lord.
R2. Right? Very well. The High Court of Bombay, by the judgment order, has set aside concurrent findings recorded by the Debt Recovery Tribunal, so and so, and Debt Recovery Appellate Tribunal, so and so, whereby sale certificate issued in favor of Mrs. Joanna was set aside on the ground of fraud. Stop. While holding so, the High Court has granted liberty to the borrower and the landowner, represented by Dr. Singhvi and Mr. Shankar Narayan respectively, to amend the pending application before the DRT so and so under section 17 of the Surfacing Act. All points have been kept open for the DRT to decide. Insofar as the sale is concerned, we do not find any specific observation having been made by the High Court, and it is this aspect that needs to be dealt with.
Sorry, my lord, sorry for the interruption.
Yes,
The
sir.
High Court has set aside the orders of courts below, which had set aside the sale. So the High Court's order, my
That
lord,
means the
is
sale revives. That
Yes,
means the
revives.
sale revives. And that is
And
what the
therefore,
High
my
Court
lord-
should have addressed. It should have said something about this, that either the sale will abide by the result of the DRT,
That's correct.
that you will not alienate or encumber.
That's the
my lord,
problem.
it has said,
The
it
High
has
Court
said
has
in
gone
para
wrong.
30. It has said in para 30, my lord, then all questions
All
are left
points are
open.
kept open.
It goes back.
No, that's not the point.
When the sale certificate is set aside by the DRAT,
My lord.
DRAT's order is set aside by the High Court,
Yes, my lord.
sale certificate would revive.
Yes, my lord.
So where is the observation with regard to the sale certificate which now revives? You are
Lord,
not under any condition.
That's
You
right.
can
there is no condition.
You
No
can
That
condition
is why
is
his
imposed.
statement is vital. His statement
That
is
is
vital.
why we are saying this, sir. We are conscious that this is the limited point where the High Court should have made some
All
observation.
right, your lordship may send it
This
back
will you have submitted.
as your lordship pleases.
Right. We record the submission of Mr. Rodgi to the effect that Mrs. Joanna has mortgaged the property with Punjab National Bank, and that she intends to pay the installments on time. We also record Mr. Rodgi's submission till such time the DRT proceeds to decide the Section 17 application on merits de novo in terms of the order passed by the High Court. Mrs. Joanna shall not encumber, alienate, or dispose of the property without obtaining the leave of the DRT. It is also sufficient that obtaining the liberty granted by the High Court, the borrower and the landowner have filed applications for amendment which are pending consideration before the DRT. This is correct narration of facts?
That's correct, my lord.
Yes.
I just want to clarify, in fairness, I, the landowner, have not filed. Mr. Singhvi, Dr. Singhvi's
Borrower
client has
filed,
filed.
not landowner.
Yes.
Only the borrower has filed application for amendment of the section.
It's only his essay, my lords. No other essay.
Having
We are
the
seeking
aforesaid
improvement in his
conditions
essay.
and circumstances, we dispose of these special leave petitions, granting liberty to the DRT to consider the application for amendment of the Section 17 application filed by the borrower in accordance with law. The DRT shall thereafter be at liberty to decide the issue finally upon granting adequate opportunity of hearing to
That's
all the
right.
parties, including the secured creditor, which, in this case is Union Bank of India.
Union Bank of.
And the landowner.
Till such time, the DRT decides the Section 17 application, the undertaking given by Mr. Rodgi on behalf of Mrs. Joanna shall remain operative.
Grateful.
Stop. It is also made clear that should Mrs. Joanna fail to pay the installments on time and the Punjab National Bank wishes to proceed against Mrs. Joanna, it shall be under an obligation to obtain the leave of the DRT.
Grateful.
We reiterate that all points on merits are left open for the parties to urge before the DRT for a reasoned decision by it.
Grateful.
Deeply obliged.
Yes, my lord, I am appearing on behalf of the petitioner.
The appeal has been
My
dismissed.
lord, here,
Co-accused appeal against the same order has been dismissed, madam. So,
my lord, it has served more than 15 years
so that liberty
in
will be
prison,
there.
and identification is, my lord, only one thing,
Then-
identifications through
Anyone don't
TIP,
dismiss-
which is vitiated, my lord. Kindly
There is-
see page 70.
said to be behind bars for more than 15 years, then that template order. Okay. 38.
I appear for a petition in this matter, Miller.
Yes.
But this is a 138 proceedings.
Sir, you have been let off leniently. Huh?
Miller,
Check is of 15 lakh plus and fine is
Yes,
only
Lord.
6 lakh plus. Do you
Miller,
want
what
us
has happened?
as to why
Miller,
you should
he
not be
claims,
sent to
Lord, that-
prison? You want notice to be issued as to why you should not be sent to prison apart from fine? Sorry.
But I wouldn't want that. But
Dismissed.
grateful.
May I please?
39.
Lord, I am appearing in 39.
Yes.
Yes, my lord.
Yes, Mr.
Lord,
Singhi, para 14.
Yes, my lord. Para 14.
Reasons
Yes,
are given.
my lord, 44 lakhs is my annual return. And the income assessed is 25 lakhs a month, which translates to 3 crores as opposed to 44 lakhs. And my lord, this is on the basis that we are a family of Aligarh. I am having a big house in Aligarh, not in Delhi or in a metro, my lord. And my lord, we had 4 children. This marriage is of 23 years and 26 years. And 4 children, out of whom 3 I am bringing up. The 4th child is with the mother. He is a major. And my lord, this is highly excessive. I'm spending a lot of money in bringing up my children. They are studying. My lord, 3 crores plus a car.
Maintenance, Mr. Singhvi. Three concurrent findings are there. Why
Yes.
should we interfere?
My lord,
You-
this is really an
Get it
assessment.
thrashed out before the trial magistrate.
Pardon, my lord?
This stage.
My lord, kindly see.
No, not
Kindly
at this
see.
stage. Not at this stage.
My lord, just because I am bringing up my children in a good way, they are studying abroad. Therefore, to assume that, in fact, that should be a factor in my favor.
There are concurrent
How do I
findings
shed out
of
so much
fact
money, my lord?
leading to award of interim maintenance to the respondent by 3 courts. In such view of the matter, we are not inclined to interfere at this stage, leaving all points open for the petitioner to argue before the trial magistrate. The special petition stands dismissed.
Okay.
Yes. Item number 40.
Whereas I am appearing for the petitioner ballots. Whereas I am protected by Honorable High Court of Gujarat for all coercive method ballots. And I appeared before the investigation agency. This is point number 2.
Proceedings are pending before the Gujarat High Court. Why do you come with a 32 petition?
Malicious, on 16th of April 2026, after no coercive action protected by the Honorable High Court, they have freeze my 6 bank accounts.
For the High Court, sir.
Additional bank account
Once
balance.
we will entertain a 32. Sorry. Dismissed with liberty to
I'm
approach the
withdrawing it, Malicious.
jurisdiction.
I'm withdrawing it, Malicious.
Very well. Dismissed as with. Forty-one last day also nobody appeared. Huh? 41 anybody? Or a second call maker. नहीं आएगा. Pass over.
My lord, 42 is also a foreigners tribunal matter.
Foreigner Tribunal 42. 43 adjourned as per letter.
44.
44.
44, my lord, Mr. Vikas Ranjan Bhattacharya leads us, my lord.
Yes.
And I am with him, my lord. I'll make the second submission. There are I think 4 or 5 matters.
Well, we are for the respondents.
Main
We are
matter
for
is
the respondents,
my lord.
We are for the caveator.
We are for the caveators.
We
appear for the. We are for the caveators.
Mr. Gupta for.
I appear in point 1, my lords, for the petitioner.
Argue for the petitioner.
I'm sorry, my lords, I
Point is
can't.
very short term that the Honorable Court did not really go by the principles of Article 14 and 16 when there is a basic allegation of institutional fraud. The learned judge records anyway, the appointees are not responsible, but that cannot be a ground to uphold the appointments which are made absolutely in violation of law. And on basis of the money, there has been a CBI investigation. CBI investigation noted huge crores of money were exchanged for the purpose of this appointment. Now, this requires consideration by this Honorable Court.
But actually, we have been working for 9.5 years now. There are no allegations against any individual.
Atwalia, we are not passing any interim order at this stage. But today, if the allegation is this, that the candidates who have been appointed,
Yes.
they do not possess essential qualifications.
Yes.
What will be the
Well, it is not the
effect of it?
allegation.
There is no such case.
No, this is not correct.
This is pertaining to appointment of primary teachers.
Yes.
Correct.
2016, the process was initiated. We would like to know, after the primary education board is served with notice, how many of the selected teachers had TET?
Yes.
That is we had.
All of them.
We all had
We
TET.
had.
Everyone had.
We are all
All
TET
of them.
qualified.
All of these
We are all
teachers-
TET.
If all the
Let the
teachers
record
have
be
the
produced,
TET,
it will
it
be
was a
apparent.
struggle.
Kindly see the advertisement.
We are all If I can just
Mr.
respond.
Bandyopadhyay, if the advertisement does not say about TET qualification, that does not take away the rigors of section 23.
We all have
advertisement
TET,
says-
my
We
lord.
have
We all
all
have
of them. They have
Kindly-
TET.
All of you have
advertisement.
it, then well
TET is
and
not
good.
the point, my lord.
They
We have
are
all
all
actually
TET.
qualified, my lord, after
Then
participating
Madam,
in
I
the
appear for the board, my lord.
Kindly, my lord,
No,
one
I
is
appear
comes
for
to
the board.
the only point which was agitated.
If you are not touching your appointment right now,
Till
if you are not touching your appointment right now, you
kindly
continue.
come. All right, Milord,
No, my lord,
kindly let the
it has
court
been,
decide.
say that, my lord,
Can make
CBI
submission, my lord.
Kindly
My lord,
see
the
page
petition
one,
was
paragraph
filed after
190.
5 years from the
CBI
expiry
has
of 10 months.
segregated, my lord. It
Kindly
is
come
not
to
like the
page
SSC
308,
matter where
my
the
lord.
CBI couldn't segregate.
My lord, kindly come to page 308.
Anybody, today, if anybody is found 5 days prior to his superannuation that he did not have the essential qualification,
Please,
do
my
you
lord.
mean to say that the employer has
No,
no
my lord,
right
we
to
had the
terminate his
essential
service?
All of us
qualifications, my
have,
lord.
my lord, the essential qualification.
We are all
The point which is being agitated.
Qualification is not an issue here, my lord.
Notice,
Not everybody has
in
May I, my
better
lord, once,
times,
my lord,
One-
point of
Kindly
order.
come to page 308.
My lord, the
My
petition
lord, one
is,
submission.
Milord, can I request kindly come to page 308?
One submission.
my lord,
Milord, is
Mr.
it Milord hearing
Bandyopadhyay,
today?
Mr. Bandyopadhyay and other learned senior counsel, can you have any right of audience at the stage of issuing of notice?
No.
That is all right, but your
If you
lordship,
don't have a right of audience,
Milord,
please
your lordship
bear
is
with
making
us.
an observe. Milord,
To come
what I
with
am
your
saying.
counters, we will consider. We
Milord,
have not issued any order of stay. If you were to issue an order of stay under 148 capital A, you definitely have a right.
Milord, only one request. Your lordship is making one observation, which I am observation
your
is not
lordship is not
correct.
audible.
Kindly
And
let
our endeavor is to find out that our children are taught
Yes.
by people who are duly qualified.
certainly.
Your lordship
Certainly,
is not audible.
cannot have any objection there. So
No,
what
certainly not.
if we endeavor to find out whether the teachers whose appointments were cancelled, whether they had the basic qualifications or not, stand in the way.
Milord, that's the reason I am requesting to your lordship kindly come
An
to
early returnable date. An early returnable date.
Yes, that is
My lord,
important.
may I make one submission, my
Early
lord?
returnable date.
Consider early or
May
later
I
on,
make
it will
submission?
come after the partial working days. It cannot
All right,
be
my lord.
decided
In
on-
July or
Please, my
August,
lord.
your lordship may
Please.
keep it.
Lord,
in.
My lord,
I
come.
Let them accept the
wanted to
notice,
say
Milord,
something.
then formalities be waived.
Lord, can I
Whoever
make a
is on
short submission?
caveat, service need not be affected, dispensed
Yes.
with. But
Lord,
service
I also
State of
appear
West
on
Bengal,
caveat.
service on the primary education board, and
are
whoever
absolutely-
is public official
We are here, my lord.
have to be served.
Primary
Mr. Gupta, you are
Education
appearing?
Board is here, my lord. We'll accept service.
Acha,
Mr.
for
Gupta
whom,
is
Mr.
here.
Gupta?
My lord,
The
your
primary
lordship put a
education board, I
question, my lord.
believe.
Your lordship put a question. They are all TET trained, my lord. That is not a problem, my lord. Your lordship
Very
wishes
well,
to hear
we'll
the matter,
consider
we'll
that.
file.
First, we have to satisfy ourselves.
Yes,
Your lordship, just one other point. One other point on notice. We are all caveators who are appellants before the High Court, but
You can
are
well imagine that if we have to encounter this at the notice stage, what will happen after the final year?
Yes.
May I make the question, your lordships, part
we have all the
Let the
qualifications
records
based
be
on affidavit.
disclosed.
No difficulty.
Records
Petition
be
was not
disclosed.
maintainable.
Everything.
13,000
Don't worry,
teachers,
Mr.
without
Bhattacharya.
being heard, they were
You are only
terminated.
running after
lordships, we are caveators who are
And
appellants before the High Court.
once sees
Your
paragraph
lordships, we are
190
caveators who
where
are
the
appellants
CBI
before
has
the High
said that
Court,
we are not
but the
the
appeal
group
is
of
not being
persons.
filed in
My
our
lord, may I
matter.
make
Purchasing
one
job
Out of
submission?
by
44
money.
appeal is being filed in one case.
We are all appellants before the High Court.
But
We are all
I
appellants
think once
before
your
High Court.
lordship
Lordship,
issue
you may be
notice,
heard.
we'll come back in July, my lord. I don't think this is really
Yes,
necessary today.
in better times.
Yes, my lord, we will file in July. Your lordships will hear us in
Very
July.
well.
There's no
Yes.
For the caveat by
the opening statements which were made, the impression which we gave to the court was totally wrong.
released in the third week of August.
My lord.
Third week of
August.
We may also be allowed to file counters, my lord.
Everyone.
Caveators.
Allowing everyone to file counter, whoever is served. or whoever is appearing on caveat. Yes, next.
My lord, my lord.
45.
45, I beg to appear for.
Madam, is there no intra-court appeal available before the Allahabad High Court?
My lords, there is, my lords.
Item 45.
There is, my lords. I'm sorry.
Then why have you come directly?
I am sorry, my lords. I did not even notice this. Would your lordships
I'll tell you
record
why.
my
I'll
statement
tell
and
you
permit
why.
me to?
The limitation is 60 days. 60 days. And you have already crossed 600 days. So you thought, let us take a chance before the
My lords,
Supreme.
I apologize. Your lordships may record my statement and permit me to go back, my lords. I
All
apologize.
right.
Madam seeks leave to withdraw this special leave petition with liberty to file an intra-court appeal before the High Court. Permission granted. Liberty as prayed.
I'm grateful.
46.
Lords, may I seek a password, my lords? Please, my lords.
Passover. Yes.
Please, my lords.
Passover 46.
So I appear for the petitioners in 47. This is the Axis Bank regarding the deposit of large amounts of money.
Mr. Gopal, you will have to deposit the money with the registry.
Manoj, I'm the petitioner. I had to accept the money from the person who was depositing.
Right. So you are now the petitioner appellant before us.
Yes, but that money has never been given to me. So if
May not be given to you,
will deposit
but
it,
the
we'll
direction is that you will have to refund.
Yes.
So if you want a stay of the order, we are putting you to terms.
Very well.
Getting the stay order, you will have to deposit this 3 crore 19
right
with the registry.
May I, lordship, with your indulgence, lordship, that we may be permitted to withdraw the
No,
amount
no,
subject to bank guarantee? No, 1 minute, lordship.
all.
I'm just simply
No,
saying
no.
subject to bank guarantee.
Mr. Kohli, you will have to decide this matter. Your money was not accepted across the counter.
Then lordship may hear me for a minute.
If
Lordship
you
may hear me
succeed, you will
only
get
for a
back
minute.
the money. They are keeping it in deposit.
Lordship may hear me only for a minute, only on a limited point. We never challenge demonetization. The holding is quite correct that they unilaterally prevented me from depositing. The only mechanism I had to deposit if I was KYC, I was KYC. And therefore, they create an internal policy in derogation of the RBI's directions. So therefore, Lordship, I've been denied my
Your
opportunity.
money will be
So it's
saved,
not
but
about
it will not be given to you.
The appeal is admitted. Stop. For a period of a
interest
month
bearing
from
FIR,
date,
Lordship.
there shall be unconditional stay of the order under appeal. Stop. If within this period of a month, the appellant deposits rupees 3 crore 19 lakhs 58,500 in the registry of this court, the order of stay shall continue till the disposal of the appeal. Should there be a default, the order shall stand vacated and it shall be open for the respondent to have the order executed before the NCDRC by instituting appropriate proceedings. Stop. Upon the deposit being made, the registry shall invest the same in a short-term interest-bearing fixed deposit account on auto-renewal basis and shall keep the account renewed until further orders to the contrary are passed by this court.
May I make one small submission?
Within 4 weeks, rejoinder, 2 weeks thereafter.
Just one small submission. We'll do this. The amount which was held by them in cash, we are unaware of what has happened. RBI has sustained our position, who is our regulator, saying during the demonetization period, if you start getting trickles of cash, 20 lakhs, 12 lakhs, 99 lakhs, we accepted the first 3. The fourth one we didn't accept because we said, where is this money coming from? Give us the source. They never.
Lordship, I can answer that.
That is our stand.
I can assist, Lordship.
Just
Now,
a minute.
Lordship, we were under protection of the Supreme Court because we had multiple rounds of litigation are there. There is no such thing about a trickle apparel. It was as many times as much as you could deposit if you are KYC.
At the final hearing.
Very well. Because their cash, we don't know what happened to it. It's all old notes.
Yes.
That should have been.
It's not about old notes. This is about deficiency of service. It's not demonetization.
48.
Grateful,
Lordship.
Yes, 48. 48. Yes, solicitor?
I'm in 49, my lords.
Oh, you are
I'm
in
sorry.
49. Then who is in 48?
No, sir. I think
My lord,
I am 48
in this. My apology, my lord. I'm in 48.
NTPC.
There is some confusion. My lord, kindly pardon me. But this is a neat question of law. Interpretation of section 28 of the new Land Acquisition Act. Please have, my lord, page 26, where the provision is quoted.
26.
At page 20, it starts at page 25. Well, I might read, my lord, the whole so that your lordships, I can give the background, my lord. Determination of market value of land by collector. The collector shall adopt the following criteria in assessing.
हेडफोन चला तो सुना
लॉक कर दीजिए.
And, I'm sorry.
1 minute, 1 minute. Yes, now you can proceed.
Yes. In assessing and determining the market value of the land, namely, A, the market value, if any, specified in the Indian Stamp Act, we are not concerned. Lord, B, we are concerned. The average sale price for similar type of land situated in the nearest village or nearest vicinity area. Or C, we are not concerned, whichever is higher, provided that the date for determination of the market value shall be the date on which the notification has been issued under section 11. Now, please see explanation, my lords. Explanation 1. The average sale price referred to in clause B shall be determined taking into account the sale deeds or the agreements to sale registered for similar type of area in the near village or near vicinity area during, please mark this, my lord, immediately preceding 3 years of the year in which such acquisition of land is proposed to be made. My lord, proposed to be made is section 8 of the Act. That is, my lord, the proposal. And, my lord, there is a purpose why, my lord, this is provided for. Lord, for which, my lord, I rely upon the standing committee report. When this act was being enacted, my lord, they have said that once a proposal is put in public domain, people start selling their lands. And therefore, that would be the right criteria to be taken into consideration. My lord, if your lordship permits, I can screen share, my lord, that part of the report. Only one, my lord, report is, one part is to be submitted, my lord. Your lordship, the court master may have to permit, my lord, screen sharing.
So in this case, you proposed acquisition in 2016?
Yes. But
a preceding 3-year period?
Yes, my lord. The section 18 is 29th April 16. Your lordships are right. So, my lord, it could have been 3 years prior.
2013.
Correct. But the court has, my lord, held that it would be from section 11 notification 3 years.
No.
That is, my lord, page 30.
Where is that finding?
Page 30, my lords.
No, paragraph 30.
No, page 30, para 22. My lord, which is contrary to, my lord, what was the intention? My lord, this was a issue which was debated, that the moment section 8 notification comes, there are transactions. Your lordship gets para 22? Can I read with your lordship? This court is of the considered view that the arguments advanced by learned ASGI appearing for NTPC Limited are devoid of any merits on account of the following reasons. On the point of taking 29th April 2016, now that is section 8, as cutoff date for computing the period of preceding 3 years to determine market value of the acquired land for payment of compensation. If the argument of NTPC Limited that the preceding 3 years for determination of market value is to be related to 29th April 26, when fresh application for initiation of land acquisition proceedings was made after proceeding lapsed under the old act, is accepted, it would lead to a situation that the 3 years prior to 29th April would be taken into consideration for determination of market value on the basis of issuance of notification under section 11, which is in the present case is 12th June 19. If such argument is accepted, it would lead to a situation that any sale deed from 29th April 2016 till 11 June 2019 will not be taken into consideration to determine the market value as on the date of notification under Section 11. Such is not the intention of the legislature. The legislature has clearly and unequivocal words provided under Section 26 itself that the date for determination of market value shall be the date. So when I am computing it, it will have to be today.
But sir, if you issue the 11 notification in 19,
yes,
that is the proposal for initiation of land acquisition.
No, my lord, the proposal is Section 8, my lord, if your lordships can see.
एक बार law दिखाइए ना. 2013 Land Acquisition Act.
2013, my lord. And if your lordship permits me, I'll screen share the report of the standing committee.
Fair Compensation Act, 2013.
It's a right to fair compensation and transparency in land acquisition, so and so act.
Section 8.
8, my lords. Possibly page 15 in your lordship's copy, my lord, we have the same. Examination of proposals for the land acquisition and social impact assessment report by appropriate government. The appropriate government shall ensure that, your lordships can skip. 2. The appropriate government shall examine the report of the collector, if any, and the report of the expert group, your lordships can skip. 3. The decision of the appropriate government shall be made available in local language to the panchayat, municipality, or municipal corporation as the case may be, and the offices of the district collector, subdivisional magistrate, and the tehsil shall be published in affected areas in such manner as may be prescribed and uploaded on the website of the appropriate government, provided that where land is sought to be acquired for the purpose as specified. Lord, we are not concerned with that. That may not assist your lordship either way. Lord, kindly see. I just
Here,
read.
Mr. Solicitor, there has been a gap of 3 years.
Yes, my lord.
If you say that proposal is in 16, Section 11 notification is in 19.
Yes, lord.
Now, if it is more than 3 years, say, let us say 5 years, 7 years, then the entire object of this act gets frustrated.
Lord, the object we will get,
As
my
the
lord,
High
from
Court has
the
correctly held, within that gap period of 16 to 19, whatever sales take place would be rendered insignificant, inconsequential.
It can also be taken into consideration. Law provides prior to Section 18, Section 8. My lord, may I just read? My lord, I'm unable to hand over the copy.
Proposal would be for a different purpose. This proposal would not fit in.
Lord, can I read, my lord, the report?
Such acquisition of land is proposed
Lord,
to be made.
can I circulate the report of the standing
Proposal
committee?
states so far as the authority is concerned, who is acquiring and for whom it is being acquired. But so far as the public at large, 11 is the proposal. It
Lord,
cannot be antedated to
No, my lord,
proposal.
11 is not the proposal. My lord, 11, please have a look at, my lord.
No, 11 is a proposal in the sense, if we go back to say 18
Section 4, Section 4.
Section 4, 5A.
Yes.
If I give a valid objection, your proposal does not go forward if my objection is accepted. So 4 is a proposal stage.
My lord, may I just, my lord, read? I am unable to hand over. My lord, this might need examination. I may succeed or fail.
No. In a proper case, you argue, but this one.
My lord, can I read? My lord, for my satisfaction, can I read?
Decimal entries. No, sir,
Lord,
not in this case. Not in this.
My lord, can I read, my lord, the report of the standing
We are
committee?
not prepared to accept that 8th proposal is the proposal referred to in Section 26.
My lord, can I, my lord, read for my satisfaction? It gives a direct answer.
Read it.
My lord, I'm sorry, my lord, if your lordships can allow a screen sharing.
We will go by the plain words of the statute. We will not go by any committee report now.
No, my lord, this is the committee report based upon which the act was made.
Maybe, but it is an external tool.
Lord, I'll just read. My lord, please allow me to.
If the language of the statute is plain and clear, why
Yes.
should we adopt tools of interpretation?
May I read? My lord, your lordships may take that call, my lord, a little later. Can I
So
read?
if there is a proposal, the social impact assessment report, if it takes 2 years to come, thereafter government takes another 2 years to consider the social impact assessment report and then issues the 11 notification. Why should this sale transaction in between?
Section,
When people may not be knowing that it is under acquisition proposal, why should it be?
May I, my lord, unless your lordships allow me to read, maybe I'll not be able to, my lord, bring forward my point.
Please read.
May I read? On suggestion of the government of, this is, my lord, the Standing Committee of Parliament, discussing this particular bill, which become an act. On suggestion of the government of Madhya Pradesh regarding application of clause 11.4 of the bill that seeks to ban all kind of land transactions of the appropriate land before SIA is that is, my lord, social impact assessment is conducted so as to, I'm sorry, my lord.
Yes, please continue.
No, your lordships would not get it in the file.
No, we are not.
Attached.
No, I know that it's not in the file. You said so.
SIA is conducted so as to restrain mischief mongers from artificially ballooning the prices of land. The DOLR stated that a social impact assessment needs to be conducted before notification under clause 11. However, to contain, please mark this, artificial inflation of prices, a calculation of market value in clause 26, the time of period of preceding 3 years should be taken into account from, by kindly mark, the date of SIA notification. This is what, my lord, was contemplated by the Standing Committee. My lord, kindly allow me to, my lord, place this on record. My lord, this would apply, my lord, pan-India. My lord, kindly allow me the genesis, the very foundation on which the act came into force. They say that
if the authority takes 5 years for the issuance of the 11 notification, anything done in between will be rendered redundant.
Then explanation 1 will become OTOs.
No.
Explanation 1 will become OTOs.
The Act should have made it clear what is meant by proposal. It cannot be just referred to Section 8.
Well, that your lordships will necessarily get, my submission is, from the Standing Committee report.
No, sorry, sir.
Well, would your lordship say question of law is kept open?
Question of law is, you want that?
Yes, my lord. In facts of this case, my lord. Because there is genuinely, my lord, it's an arguable case. Now that your lordships have dismissed, I am saying, it is an arguable case, my lords.
But Mr. Solicitor, if we pass a single one-line order, that doesn't mean that the Supreme Court has upheld the order of the High Court on. It's absolutely open to you.
Better not to leave it to other.
It's a single bench order.
Lord,
in some other High Court, it may have been only of a persuasive value.
Lord, better not to leave it to others to interpret your lordship's order.
We are, you know, in our judicial academy, we are deliberating on this. Let us tell you, a single judge takes enormous effort to write a judgment, 15 pages. How much time does it go behind writing a 15-page judgment? At least 2 hours in chamber. Matter comes up before a division bench. Division bench takes another 2 hours at the residential chamber to write its own judgment, affirming the single bench order. Matter comes up before the Supreme Court, and we say, not a question of law is kept open. What happens to the judicial time that is wasted there?
Lord, I may not have any answer to that. Would your lordship say in facts of the case?
Yeah. So therefore, we will have to keep the question of law open only in those cases where there is doubt evidently, palpable on the face of it.
Would your lordship say in facts of the case dismissed?
This is not such a case. So one-line dismissal.
I'm not insisting for.
There is no merger. There is no merger. That judgment is open. You go in a similar case and say that it doesn't mean that the Supreme Court has affirmed the judgment of the Jharkhand High Court. It's
only one, but I'll not request for question of law. Would your lordship say in facts of the case?
Nothing more. We are not inclined to interfere. Dismissed.
Please, your lordship.
Obliged, my lord.
Yes, 61.
Lord, item 49, Lord.
Now we are on 61.
May it please,
Oh, I
Manoj.
see.
In-
I did-
49, perhaps post notice.
Yes, the Lordship will come after vacation. Lord.
Uh,
I'll tell you why, Lord. This is that matter regarding that MSME. The latest RBI circular has to be shown to your Lordship. That's why. I don't know when your Lordship will take it up. Or shall I wait? Whatever your Lordship.
if you are not available, we will keep it after vacation.
No.
Let
I'm available. I'm fully available, Lord. I'm not waiting.
We want to finish up the fresh matters.
All right. I'll wait.
And
I'll
then
wait.
come to post notice matters.
I'll wait.
Yes, item 61.
May it please,
My
Manoj.
lord, the petitioner and my lord, the Honorable the High Court dismissed the matter because to consider the allegations on me and direction to the surrender before the
Amanullah,
Yes, my lord.
complaint case.
My lords, exactly. So, my lords, Om Prakash versus State of Jharkhand, my lordships, as early as April of this year, has clarified that in complaint cases, a summons has to go. It is only if the summons doesn't go that there are other processes to be
If
followed.
he is appearing before the court, where is the question of an apprehension of arrest?
Exactly, my lords. However, my lords, in this case, what the impugned order does is that the impugned order dismisses the anticipatory, but it also says that the SP will arrest if he doesn't surrender.
That is
And
not
my
wrong.
lords is, in my respectful submission, my lords, erroneous because
What is the citation of Justice Patiwala's order?
2026 SCC online SC 676.
Very well. Leave granted. The impugned judgment and order is in the teeth of the judgment and order of this court, reported in so. Accordingly, the impugned judgment and order stands set aside. We make it clear that the appellant shall appear before the trial court on each and every date fixed for trial unless exemption is granted in accordance with law.
Grateful, my lords. Would my lords permit me to give my appearance in the chat box?
Just before the court, no coercive steps shall be taken.
I'm grateful. My lords, could I give my appearance in the chat box, please?
Yes.
I'm so grateful.
Item 62. Yes, Madam Prakash.
My lord, it appears that a land dispute has led to institution of 3 cases. One,
Notice.
All right.
I think we've lost the connection.
Notice interim. 63.
My lords, it seems, my lords, the order is, despite my lord's order, no cognizance has been taken by the National Commission to, my lords,
Tomorrow, sir.
my lords, still, my lords,
I accept
1 crore
notice
is
on
there.
behalf of the state in item number 62, my lord.
Yes, 62, Mr. Counsel accepts notice. File your counter. Rejoinder.
Yes, sir.
Come up in the 3rd week of August.
My lords had passed an order in September. Despite that, my lords, no effective steps were taken, my lords. And my lords, this is not only in this matter, in every matter, my lords, the execution is not moving, my lords. And we are at a situation where, my lords, CC complaint takes 2 years, execution is taking 4 to 5 years now, my lords.
What can be done?
What can be done?
What can be
My lord,
done?
I think guidelines have to be followed. Rahul S. Shah, my lords, had laid down guidelines. But
There are guidelines given by this court. Even then, the tribunals are not being able to abide by what? How can we say that they are not trying?
my lord, because after my lord's order, even 70 did not start the section.
How many
proceedings
cases
70
are there and how many courts are functioning? All these things have to be taken into consideration.
My lord, 6 hearings after my lord's order, yet my lord, no cognizance has been taken. That is after my lord passed an order in September to conclude it by March, my lord, still no
The
cognizance was
execution
taken.
is fixed before the NCDRC tomorrow. In such view of the matter, we are not.
My lord, but keep it in a time-bound manner, my lord, extend it by 3 more months and say even close in 3 more months. That is, my lord, can be done.
To the petitioner to persuade the NCDRC to close the execution case as early as possible in terms of the earlier order passed by this court, as well as the order dated. Well, you have the citation of Justice Patiwala's order that all execution cases should be disposed of within 6 months.
Yeah, my lord, yes, that is Rahul S. Shah, the earlier judgment.
Just send it to the court master.
I'll send it to the court master. I'll send it to you.
Yes. Next,
Grateful, my lords.
item 64.
Dismiss.
Very well. Mr. Diwan, we can't hear you.
Is your lordship able to hear me?
Yes, loud and
I can't have three.
No. This is one.
No,
You did-
again,
Okay.
again disruption.
Where's your volume? Can your lordship hear me?
Yes, we can hear you.
Where's your volume? Can your lordships hear me this time?
Yes, sir, we can hear you.
Yes. So, Manoj, may I just make the point? I apologize that we've been having some trouble with the.
You can use this.
No, just.
You can use this.
Again, there is a disruption. Huh?
Manoj,
There is a network issue.
I think the problem may be at my end. I apologize for that. Your lordships can now hear me?
Yes, yes, yes.
Yes. May I just state the point? This is an issue which, according to us, raises an important question of law. And the issue is really the interplay between sections 9 and 9A of the Minerals Development and Regulation Act. Now, I'll just tell your lordships what has happened. And please, may I do so with reference to the impugned communication, which is at page 577, 578. Your lordships also have the Mines and Minerals Development and Regulation Act available. We had sent it to the court master.
Yes.
Your lordships have 577, 578?
Yes, 577, we have it.
Yes. Now, this is the impugned demand which I was constrained to challenge. Now, this demand, your lordships will see, is in respect of royalty, payment of royalty, third line in the impugned communication, and also subject. Your lordship has that. Now, royalty is referable to section 9 of the Act. And section 9 mandates that the royalty would be liable on removal of the material or on consumption of the material. So until there is removal or consumption, there is no levy of royalty under section 9. However, there can be a levy of dead rent. Just keep this concept of dead rent just separate under section 9 capital A. Now, there is, in the facts and circumstances of our case, the removal started only after the consent to operate. There is a mining plan approval. The mining plan approval granted by the central government mandates that you cannot operate this mine until you have until all the environmental permissions are received. And in the facts and circumstances here, those environmental permission would be the consent to operate. So just keep that in view. I have, once the consent to operate was issued to me, been paying royalty. So there's no dispute on that at all. What the impugned demand does is that it seeks to impose royalty, demand royalty for a time before I had the consent to operate on a notional basis. Now that cannot be done because the statute contemplates that until such time as there is removal and consumption, you have to pay dead rent. And here your lordships may note that I have been paying dead rent throughout the requisite period and there is no demand for dead rent. Now, may I just, we have sent it to the court master, the sections. May I just place the sections before you? So your lordships have it because there's an interpretation issue here. Section 9, first.
Why did you take the trouble of sending the entire act in a paper book? We have the enactments with us in
Okay,
court.
we'll keep
This
that
is
in mind.
sheer wastage of paper.
Oh, I'm so sorry. So would your lordship just take up section 9? We are concerned with 9.2.
9.2.
Your lordship has it? Royalties in respect of mining leases?
Yes.
Yes. Now I'll take you straight away to 9.2. The holder of a mining lease granted on or after the commencement of this act shall pay royalty in respect of any mineral, now mark the words, removed or consumed by him or his agent, manager, employees, contractor, or sublessee from the leased area at the rate for the time being specified in the second schedule in respect of the mineral. So your lordships have seen it has to be on the mineral removed or consumed by him. Now, in my case, the consent to operate, your lordship may just note that date, the CTO was issued in my case on 26th October 2023. 26th October 2023. And I have been paying royalty at the requisite rate from 26th October 2023. Now, what is to happen before that? So there is a provision in the statute for that as well. And your lordship will find that in section 9, capital A.
Yes.
Please take up 9A. There's a separate statutory notion of dead rent. Dead rent to be paid by the lessee. The holder of a mining lease, whether granted before or after the commencement of the Mines and Minerals Development Regulations Amendment Act 72, shall, notwithstanding anything contained in the instrument of lease or any other law for the time being in force, pay to the state government every year dead rent as such as may be specified for the time being in the third schedule for all the area included in the instrument of lease. Now the proviso is important. Provided that where the holder of such mining lease becomes liable under section 9 to pay royalty for any mineral removed or consumed by him or by his agent, manager, employee, contractor, or sublessee from the leased area, he shall be liable to pay, please mark the words, either such royalty or the dead rent in respect of that area, whichever is greater. Whichever is greater. So it's one or the other. Now, please have a look as to what, let me just indicate as to what the collector has done, and in our respectful submission, done erroneously. So your lordships has seen that impugned demand. It's at page 577, 578. Please have a look at that.
Is it for a period prior to the CTO?
Yes, it's for a period prior to CTO. So just have a look at it, please. Page 578.
CTO or no CTO,
yes,
there's a payment schedule in which says that it says this minimum production requirement. It says that first year 0.
Correct.
You're not required to take out any mineral.
Yes.
Second year is again 0.
Yes.
And it gradually increases.
Yes.
Even if the production is 0, you are not having a CTC certificate, you are required to pay the dead rent. Because when the production is 0, there cannot be any royalty.
No, so may I just note, your lordship is absolutely correct. Absolutely correct. So that's exactly my case. My case is dead rent liability is there and I have paid the dead rent liability. So there is no demand for dead rent. That's exactly my case.
I am liable. Not.
The impugned demand is for royalty. That's the problem.
Suppose that it is prior to obtaining the CTO.
Yes, your lordship will see that from the demand itself.
Where is that?
Would your lordship like to have a look at the CTO? It's at page 486. It is dated 26th October 23.
486.
Your lordship has 26th October 23.
Yes.
So this is my consent to operate.
Yes.
So your lordship has noted the date, which is most important for our purposes, 26th October 2023.
Right.
Now, please see the impugned demand at page 578. He's starting the impugned demand from 1st April 22. I'll explain to you how. 22-23, and then 23-24, and then 24-25. I have paid royalty on and after the CTO date. Now, how has he gone about it? So I have also paid dead rent for the earlier period, so there's no demand for dead rent. The High Court has confused itself and said, followed a precedent of dead rent for the purposes of royalty when the concepts are statutorily completely distinct. Now, please have a look, if your lordships would, as to how the collector has proceeded. This is on the basis of page 309, which is the erroneous basis. Yes. May I, with your permission, before I take you to that, just show you 107, please, and then I'll take you to 309 right away. Just go to 107. 107, annex your P5. Now, this document at 107, 27th November 2019, is what allows me to proceed because it's my approval of the mining plan for my mine. Please notice this. Subject, this is from the central government. Approval of mining plan submitted by you for grant of mining lease for so-and-so limestone deposit.
Please wait, please.
Yes, certainly.
Then senior counsel appearing for the petitioner submits that the impugned demand notice dated 17th March 2026 claims royalty from the petitioner for a period prior to obtaining the consent to operate into bracket obtained on 26th October 2023. According to him, in terms of the provisions of Section 9, royalty can be demanded only if the mining leaseholder removes or consumes minerals, which did not happen prior to the consent to operate was issued. We record Mr. Diwan's statement that the petitioner had been paying the dead rent till such time the consent to operate was issued. He should notice stay of the demand.
I'm grateful.
Yes, please.
Wait, please, my lords. I'm appearing for the petitioner in item number 65, my lords. Now, in this case, my lords, the order of the registration of FIR, my lords, it culminated vide the order of the learned judicial magistrate, my lord. Now, the investigation was at a nascent stage, wherein specific allegations for inducement of the complainant was made against all the accused persons, my lords. At the threshold, my lords, unfortunately, my lord, the entire FIR is quashed.
Because arbitration clause in the LLP agreement?
Yes, my lords, arbitration clause was there, but despite the arbitration clause, my lords, there was specific instances of my lords criminality involved in that, and the investigating officer.
You are giving a criminal color to a civil dispute.
My lords, may kindly see the specific allegations, my lords.
Very exhaustive. Let it be.
My lords, my contention, my lords, even the learned, the investigating officer has found instances of forgery in that, my lords.
Let it be, you please.
66.
I'm appearing for the respondent, my lords.
He wants to.
Take it. When?
After 2 weeks, notices क्या stay दे दिए तो एक तो
Why after 2 weeks?
Well, this has been adjourned fourth time. Fourth time adjournment has been taken, but
Last and
it can
final,
be-
Lord. Last and
this-
final, Lord. After vacation,
well, this can be heard this side of the vacation. Well, that's
We'll
all
keep
I'm
it on
saying.
next Friday.
Very well.
Lord,
Lord.
Lordship may take it up after vacation, Lord.
Very well, Monday.
Very well.
Lord.
Yes.
Monday as last opportunity. Yes, 67.
One SL.
May it please your lordship. Lord, this your lordship had this had come up on the last day when your lordship was noticing that one SLP had been dismissed against the same judgment.
Yes.
Now, and then when I said it was different, your lordship said your lordship had not seen it. Now the point here is we have already been appointed as assistant teachers from March 22 to April 23. The only impediment in our appointment at that time, we are B.Ed qualified. At that time, the only impediment was the state rule said we must have 50% at graduation before getting admitted to B.Ed. That NCT clarified in 2019 saying that for those who have done B.Ed prior to 1st January 2011, that 50% in graduation will not apply. There are 3 judgments, 2 of the High Courts, 1 of your lordships. When they did not allow us to compete, we went to the High Court. High Court said, yes, I'll read that interim order, that these people have done it from before 11. They have to be allowed to compete. We were allowed to compete. We got appointed. And we have been continuing since then. Thereafter, my lord, comes Divesh Kumar's judgment on 11th August 2023, after all of us had been appointed, which said B.Ed is not a valid qualification for those who are yet to be appointed after our judgment. I will read that clarification application to your lordships. Now, the SLP which came earlier are those people who had not been appointed. And they said against the remaining vacancies, please appoint us also. Your lordship said, no, we are not going to entertain. So far as I am concerned, my High Court has not decided my controversy. High Court says because Divesh Kumar has come, your writ is dismissed. I filed a review saying Divesh Kumar has nothing to do with me. That was not my controversy. My controversy was whether I have 50% is required or not. That your lordships have decided. I am continuing now for the last 4 years.
What about this Kuldeep Dabral versus State of Uttarakhand?
That is the one which I am explaining. That is the one they were not appointed. They came against subsequent vacancies. We have passed on that entire SLP paper book to your lordship's moderator just now. They were never appointed. They have nothing to do with us. We have been working for the last 4 years. Now the High Court has not decided our matter at all.
Well, Learned Senior Counsel submits that persons who had not been appointed had unsuccessfully challenged the common impugned judgment and order before this court, resulting in dismissal on so-and-so date, whereas the petitioners have been working for substantial period of time.
March 22 to April 23, we have been appointed.
March 22 to
April 2023. On different dates we have been appointed.
Till 2023, and therefore are not covered by the opposite order of this court. Issue notice. If the petitioners are in service, their service may not be disturbed.
Your lordship, what they have done after the High Court judgment now, they have passed these termination orders and issued them on, I'll just tell your lordships. Your lordship may kindly allow us to stay our termination, 2nd May 2020.
Mr. Patwalia, termination can never be stayed. Termination.
Then whatever order your lordship was saying, if we are in service, we shall not be terminated, is fair enough. We will take that.
There is a judgment, it's not a judgment, but short order, Suman Dutt versus State of Haryana.
About 30 of us have been relieved, rest are working, my lord.
If anybody is working, he will be protected, but not those who have been terminated.
All right. We will come back, my lord. Let us.
It's only at the instance of one petitioner. Or how many are there?
No, there are about 50 of them, 50 of them, my lord, in different matters. 50.
Yes, next 68.
Your Lordship, please.
How much time
I
do you
requested the court master to hand over a small note.
How much time do you require?
We require, in the application, I said we require at least 2 months' time. Would Lordship just look into the note for a minute so that I will be able to explain? Kindly look into the note, small note.
Very well, you'll get 2 months' time.
Very well, sir. Very well.
My lords,
I also want to, in fact, just to inform you, Lordship, I also want to find out if I can, because it seems to be too complex a matter. And then, your Lord, just Satish Sharma told me there's only about 25, 30, but we found out there were 2,500 applications only in civil lines. So we want to look into it.
So that is why 2 months' time. That is why 2 months' time.
No. I only want to say that I would like to take stock of it and find out if I can have a solution to the problem.
That also you do it, and you are
right.
I'm very hopeful you will find a solution for that.
Maybe it's important Lords can make an observation that having a regard to the time required, if it's possible, the solution I can push the government into thinking.
My lords, one humble submission which is very important for the city of Allahabad. My lords were pleased to order for the tabulation for 96 to 98. My lords, that will not be able to give the right situation or what exactly at the threshold or at Allahabad has happened. So my lords may kindly consider making it till 2006, my lords. Or because the things have been done after 98 on a very higher scale.
Then it will be a gargantuan scale that nobody can manage it.
Government policy of 92 and 98.
That's right.
These were the two policies. So we cannot make it 2006 if there is no government.
My lords, till 2004, may kindly consider, my lords.
No. If the policy is not there.
2004 policy.
My lords,
Case is built 92 and 98.
My lords, I vote out.
Referring to the order dated 21st April 2026, learned Mr. Venkatramani, Learned Attorney General for India, seeks and is granted until 31st July to complete the exercise of submitting the status report before this court as directed. Since we are granting sufficient time, it would be desirable if the state of Uttar Pradesh in the status report to be filed indicates an acceptable solution that would lead to putting an end to the lease.
Your Lordship, please.
Released before this bench on 12th August at 3:30 p.m.
Very grateful.
Great.
Application stands disposed of. Item 70. Yes, item 70.
Lord, 70, I'd like to appear for the petitioner. Lord, this is a matter where the judgment was closed.
What is this?
It's only clarification.
Lord, it's not clarificatory, my lord. My lord, may just have the SLP just for a moment. Let me just have the application for amendment at page 99 and 100.
Very sorry.
There are three aspects which are being amended, my lord.
Let the matter be decided.
There is a prayer which is being added after judgment is closed. 3 dates, my lord, the judgment is closed, and then thereafter they file the application for amendment, my lord. 3 dates, my lord.
Readings at the Supreme Court level.
My lord, may just have page 93. Just for a moment, my lord, may have page 93.
Cross the tribunal's hurdle. No, sorry. Sorry.
There is a new prayer being added. They are recouching the entire application now. And on top of that, they are rescinding their admission that they have made before in their appeal.
Next matter. Sorry. Next matter.
Grateful.
PC Act.
May it please, my lords. Was my application for regular bail for the now in custody. There is no sanction as of date. There is no cognizance for the last 3 months, my lords, on the charge sheet that has been filed. But I'm sorry I couldn't hear, my lords, your lordships.
Better you don't hear it.
Dismissed.
All right. Can I renew it, my lords, after then?
No, sir. My brother has issued notice.
Normally, your lordships don't joke, so I was taken aback, my lords, from you. Normally, my lords. Normally. I'm obliged, my lords.
But for a moment that we had heard by issuing notice because Mr. Dave himself was not too confident.
I'm
and
sorry.
taking time.
But no sanction is there.
Yes, my lord. I'm obliged, my lord. Grateful to you.
41.
Please, my lords. My lords, I apologize. I did not appear earlier. Actually, my lords, in this case, I had issued an NOC to the client in 2024 itself. Somehow the client has not engaged another advocate. There were two cases.
Let it go. Certified copy has not yet been applied even now. And this 1116 days delay is refiling delay is not attributable to the advocate on record. So therefore, let it go as dismissed as time barred.
Please, my lords. Obliged, my lords. Again, I apologize, my lords. I was not aware this was listed.
So 46.
My Lord, appear for the petitioner. My Lord, this is the same matter, my Lord, where the order was not uploaded. Last week we had appeared. My Lord, for 2 months the order was not uploaded. The order is of March 2026 and uploaded only on May 2026, my Lord.
Right.
But, the issue in this matter is whether, my Lord, when does the
Chitnis, please see para 14. It has been held in the facts and circumstances.
Yes, my Lord. But if your Lordship sees, my Lord, para 14, my Lord, the learned judge says that the time to take steps, my Lord, limited. If your Lordship sees the middle of the page.
Why should a litigant suffer if the DRT issues the recovery certificate late?
Lord, but that was the earlier provision was like that, Lord. I had a benefit of that. The recovery certificate issued much later, my Lord. So that when there's a debt become due, my Lord, whether it's conclusive, my Lord, it became conclusive on the first date only when the matter was adjudicated. Therefore, my Lord, time should run from that date. Lord, that issue is pending for this honorable court, my Lord. But whether the time became time started to run the first date or on the date of the recovery certificate, my Lord. So, my Lord, my submission is that it should run from the adjudication, my Lord.
Rendered its opinion in view of the.
Lord, may I just make a submission, Lord, that we are ready to pay the money, my Lord. Some indulgence.
We keep the question of law open as to whether the Limitation Act or the schedule forming part of the Income Tax Act would apply in a case where
we have made a proposal, my Lord,
in relation to the period of limitation.
It's a dwelling house, my Lord. I'm ready to make payment, Lord. Some indulgence.
Force a debt, which has been adjudicated by the DRT.
Lord, the loophole was closed after the amendment.
Survives. Certificate has been issued. Now you will have to fight it.
My Lord, I wanted to make payment, my Lord, but now, my Lord, if there was some indulgence, then I would have made some payment, my Lord.
Wanted to make payment, you would have made it long before and not drag the matter to the High Court. Sorry.
Obliged.
Dismissed. Dismissed. Next. Item 60 brother ये ऑर्डर किया है.
Item number.
Appeal.
Yes.
By directing release of the vehicle bearing MP 06HC1353 on such terms as the district magistrate may deem fit. However, we are making an observation that since the High Court is presently seized of the appeal against the conviction,
yes,
the petitioner shall be barred from disowning the vehicle in question in course of consideration of such appeal.
My Lord, we will not decide. My Lord, only thing is that if your lordships would kindly make it time bound so far as the release is concerned, because it is lying in the police station for the last many months, my Lord.
Many years.
Many years rather. So it would have become a junk by now, I think.
Then why are you asking for it? You are digging your own grave, Mr. Mukherjee, by claiming ownership of the vehicle. Anyway.
No, ownership was determined when I was convicted.
Within 2 months.
Much obliged.
Within 2 months.
Within 2 months.
Much obliged.
Yes, now next. Mr. Datta prayed for time after.
Yes. Lord, can be taken in because I want to show some letters. Lord, your Lordship's judgment, there are conflicting.
Not today.
Not today. Yes.
After
having it on another day.
after the partial working is over.
I see.
Because now we want to revive, the government has changed the policy and place those documents also. After
in August.
Grateful.
August. Can it be second week of July, my lord, if it's possible?
July 1st.
All right, August.
Miscellaneous, Mr. Datta.
Oh, okay,
we
August.
don't have much time. So August it will come.
Grateful.
Lord, that interim. Just 4th August, if it can be on 4th August, if it's possible.
Let us see, the court master will find out, you know.
All right. Deeply obliged.
ROP will find it.
My lord, interim order to continue in
Very
this
well, interim order to continue.
obliged.
Item 50.
My lord, I got the counter affidavit today only in this matter, my lord.
Rejoinder, 2 weeks.
I would file the rejoinder within a week, my lord. I request that if the matter is listed before vacation, my lord, because the Haryana matter has already been taken up in the Rajneesh Kumar.
My lord, if I may interject, my lord, for a moment here, my lord. My lord, his limited grievance before this honorable court was, my lord, that the letter which has been given to the Honorable High Court by way of which the advertisement was withdrawn was not provided, my lord.
No, my lord, this is not the only grievance. This is not true.
Allow me, my friend. I'm not yet finished. Just give me a minute. So, my lords are aware, my lord, there is a main matter which is coming up tomorrow, my lord, wherein those directions were issued, my lord, with regard to appointment of these positions across India, my lord. Tomorrow, my lord, it is coming as item 43. Nonetheless, my lord, his grievance before the High Court was, my lord, with regard to withdrawal of advertisement, since they applied and they appeared and written examination, etc., was done, my lord. My lord, my request would be, my lord, either may, my lord, permit him, my lord, to go back to the High Court. Now, my lord, that letter is also there on record, my lord. It is annexure R3, whereby, my lord, this advertisement was withdrawn for administrative reasons, my lord. If still, my lord, my lords want to hear it, my lord, I'll assist it as and when convenient, my lord. I
hear you, and tomorrow the special educator matter will not be taken up. Tomorrow I'm sitting with Justice Masi for disposing of the parted matters.
Very well.
So it will stand over.
Very well.
Special educator will stand over. One week for rejoinder. The list. Are you available in the first week of June?
Yes, my lord, I am.
Mr. Sangwan?
My lord, if my lords may permit me virtually, my lord, I'll assist the court, my lord.
Okay.
My lord, my kids are studying in US, so I'm supposed to join them.
Obliged, my lord. Obliged.
Very well.
If the lordship may allow, may I mention the item number 1 Passover matter?
Please wait. Please wait. 51. We call 50.
I pay for the statement.
Oh, there is that matter.
Yes, Lord.
Yes, my lord. Though the complainant is yet to enter appearance, but I filed an affidavit, my lord, which he has sworn to and attested. And I handed over, my lord, if your lordships kindly have a look at IA 154175 of 26. And at page 8 of that,
yes.
my lord, at page 8 of that affidavit, the complainant, my lord, who's R3, he says, my lord, in para 3, that I have resolved all my grievances with all the accused persons, including the petitioner in the present case. I do not wish to press the present complaint, FAR, any further, or any other proceedings in future against any accused persons arrayed in the present FAR. Therefore, the present FAR may kindly be quashed so as to close the present case. That I am swearing this present affidavit without any fear or undue influence, and the present affidavit may kindly be treated as my unequivocal and free consent for quashing the FAR. He filed a similar affidavit in the High Court, which your lordships have seen.
Sir, can you just tell me where it is, if you don't mind? I'm sorry, I was not able to practice.
Page 8, of IA
What,
number
sir?
154175 of 26. The lordships have it.
Just give
The
me.
lordships have seen it
We
as
have
well.
it. We have it. Mr. Luthra, it is part of IA 11541.
Just give me a moment, Lord. I'll just find. Have you got it? Just show it. I'll just see. Where is that IAC?
Mr. Giri, who is your advocate on record? Can he send it by mail to Mr.
It's
Luthra's
okay, Lord.
office?
Do we have the site? I leave it to your lordship, not to your lordship.
Sumesh Jha is there.
Mr.
I think it has already been served on Mr. Luthra's AUR.
Is our 142.
It's not served. It's okay, my Lord. It's okay, my Lord. If your lordship is satisfied, Lord, I leave it to your lordship, Lord. I've not, because I know they filed something in the High Court as per my instruction.
It's in terms of the affidavit filed before the High Court, which has already been served
Sir,
on.
I am saying something which will not harm you. As I was saying, Lord, I understand they filed the affidavit in the High Court. To that extent, I've taken instructions.
We'll exercise our 142 and
Leave it.
who are the petitioner? We have perused the affidavit filed by the respondent number 3 complainant, forming part of IA 154175 of 2026. Paragraph 2 to 4 of the said affidavit read as follows. In view of the contents of the affidavit, we invoke our power under 142 and quash
The number of the FIR is given at para 2 of the same affidavit.
09 of 2025, referred to above, paid the petition, accused number 3. Special petition is disposed of.
Yes. No, Lord, it's a writ petition.
Grateful to your lordships. It's an Article 32.
Article 32, yes.
Yes.
The writ petition is disposed of.
Okay.
We really wanted Mr. Luthra to argue on the aspect of cooperation with the investigating officer, so that we could have used it against him when he moved an application for bail. Unfortunately, we don't get that opportunity.
Lord, I must tell your lordship, in fact, I mean, now that your lordship is saying, Lord, what has happened was, and I'll give you a little background, Lord. What has happened is this issue in part, and it's a little interesting. This issue in part not is being considered in that foundation forum for professionals, Lord, and in a petition by a company called Amazon, Lord, and I'm the lawyer for Amazon. Matters pending in another bench.
Well, thank you.
But
Grateful to you.
I've got the affidavit, Lord. I've seen it also. There was some.
52.
May it please the Lordship. The counter affidavit has been filed by the state members. They accept that these two matters, the two petitioners, they were not engaged in any case which was sessions triable.
Who appears for the state of Bihar?
Lord, I am tendering my sincere apology, my lord. There has been a bona fide mistake, inadvertent mistake on the part of the state, my lord. Only regarding the cases, my lord, we have mentioned in detail, if my lordship may kindly see, at page number 4, my lord.
Page 4 of which?
Of the counter affidavit which we have filed in this MA, my lord.
Counter affidavit. Page number 4. So they have antecedents.
Yes, my lord. Regarding the antecedent, my lordship have directed them to file a status report in the SLP, my lord.
But first case, Chakai PS, he has been acquitted.
Yes, my lord. We have given the entire detail regarding the current status, my lord.
Second also acquitted.
Second also acquitted.
Third also closed.
Third closed.
Closed in National Lok Adalat, my lord. And regarding the second applicant, my lord, Raju Paswan, my lord,